Tonight we have invited two bankruptcy specialists who practice here in Huntsville. Amy Tanner and Ron Syskstus are going to talk to us tonight about bankruptcy. First of all, Amy is a lawyer who graduated from AUM, that's Auburn there in Montgomery. She grew up in Montgomery and received her undergraduate degree there and then went on to Jones School of Law. About 11 years ago, she moved to Huntsville and has specialized in consumer bankruptcy law since that time. So that means she knows a lot more than the managing partner, who will be the next speaker, about the subject. But she has specialized in it, and I will tell you, in Huntsville, she's probably the most formidable expert on the subject. Now, also, I will tell you that to let you know how lawyers think and do, she, as a hobby, runs triathlons. So I'm impressed. But she will talk to you about bankruptcy. Thereafter, we will have the managing partner of Bond, Bodis, Sykstus, Tanner, and Ezel here. Ron Sykstus is going to talk to us about security clearances. That's an issue everybody in Huntsville wants to know about. He is a graduate of Arizona and Northern Illinois. He was a captain in the JAG Corps and has lived in Huntsville for a long time, and as I said, is the managing partner of what's probably the largest bankruptcy firm in the state. But first of all, it is my honor and privilege to first present to you Amy Tanner. Amy, thank you so much for coming.
He's given me a lot to live up to in that introduction he's given me, and I have been here practicing primarily in consumer bankruptcy for the last 10 years. I hesitate to call myself an expert, but I like to say I do hope I know what I'm talking about. You may notice from the accent I was born and raised in South Alabama, so I'll try not to talk too fast or throw too much southern drawl on you as I go through tonight. But over the years, I've seen lots of people who needed bankruptcy services. They come from all walks of life and social classes and status. It's a very humbling experience for anybody who has to come and see me. Not a lot of people come lightly. It's a heartfelt decision when they come to my office to talk to me. Tons of people have told me over the years, I've done everything I could do to keep from coming to see you. Sometimes they've just struggled on for too long. I like to ensure each client that there's nothing wrong with making the decision to come to me, and then guide them through the process, which is with as much dignity and respect as we can muster there, which is usually pretty easy. There's a bad misconception out there I've noticed with lots of people who think that people just go out and run up all their credit cards and then come to me and file bankruptcy. In nearly 11 years of practice, I've really never experienced that one time. Most folks come to us when there's been a job loss, medical problem that was uninsured, many other reasons that they need it, but nobody intentionally comes to my office seeking to file bankruptcy or tried to get there in any way. There are some statistics I'd like to share with you about bankruptcy. These come from the Administrative Office of the U.S. Courts. In the past fiscal year, that would be 07 to 08, there have been nearly 1 million bankruptcies filed. These are consumer bankruptcies only. That's a 28.9% increase in the previous year. This year, we're seeing even more of an increase. If you're following the economic news at all, it's hitting everybody in all walks of life. A lot of well-known corporations are filing. If you read the Huntsville Times, you notice in the business section every day it seems like a new business has filed some form of bankruptcy. So it's hitting everybody and hitting everyone hard. Some of you locally may have even been impacted by one of the recent Bill Hurd filing if you had warranties or maintenance issues with the local dealership there. So you've got a little taste of it maybe in your own life. But these things generate down. The business filings, there's a lot of plants closing, as I know you're aware of, a lot of factory shutdowns. These things trickle down to the consumer. And that's when a lot of folks come to see me. We've seen a huge increase in consumer filings, increased by 200,000 in the past year. So that 28.9% I mentioned earlier encompasses back to approximately 200,000 consumer bankruptcy filings. I suspect that number will be even larger this year from what I'm seeing. I'll be focusing tonight, I keep mentioning consumer bankruptcies, I'll be focusing tonight mostly on Chapter 7 and Chapter 13, which those are the two forms of consumer bankruptcy. But first of all, I'm going to give you a little brief history of bankruptcy and how it was initiated or where it came from. It relates way, way back, even to the Old Testament. In Deuteronomy 15, there is a section of the Bible which scholars have dubbed the year of canceling debts, and it's particularly Deuteronomy 15 verses 1 and 2 that says at the end of every 7 years you must cancel debts. This is how it is to be done. Every creditor shall cancel the loan he has made to his fellow Israelite. He shall not require payment from his fellow Israelite or brother, because the Lord's time for canceling debts has been proclaimed. So I would say that's probably the first mention of anything about forgiving of debts. Even in the New Testament, Matthew 6:12, Jesus goes on to state, "Forgive us our debts as we have forgiven our debtors." So it has a long history. When our forefathers wrote the Constitution, they created a uniform, or they created a statute so that Congress could go on to create a uniform law on bankruptcy. There's been some form of law of bankruptcy over the last 100 years. It's currently in the form of the United States Code, Title 11. And just as an insight, let me give you a quick website. If you want to find the complete wording of that code, Title 11, you can go to www.4, that's the number 4, .law, L-A-W, .cornell, C-O-R-N-E-L-L, .edu, /US code, /11. That'll take you to the entire U.S. code. Instead of buying the big thick book to go along with it, you can go straight to it on the internet. Over the last century or so, the code has been reformed several times. Most recently, it was reformed by an act in 2005 called the Bankruptcy Abuse Prevention and Consumer Act of 2005. A lot of changes came with this act. Probably the most dramatic changes in the last 25 years of practice of bankruptcy law. A lot of folks believe that the 2005 Act was an attempt to make it harder for people to file Chapter 7 bankruptcy, the type of bankruptcy where you are able to simply discharge or wipe out your debts, and would hopefully force more people to file a Chapter 13 bankruptcy, which is a form of a repayment plan where you pay back some of your creditors. Most of the nation's filings will fall under these two headings of bankruptcy, or these two chapters of bankruptcy, Chapter 7 and Chapter 13. I'm going to talk a little more in detail now about Chapter 7's. My personal quote on a Chapter 7 is, that is what most people think of when they think of filing a bankruptcy, just getting relief from debts. We like to call it the fresh start, where you can get a new start with your debts and your life of credit. A lot of folks refer to the Chapter 7 as a straight bankruptcy. The reasoning behind this is because you can discharge or wipe out all of your unsecured debts. Unsecured debts are those things like credit cards, signature loans, medical bills, certain old accounts or closed accounts, things like that, things that don't have collateral to go along with them. Speaking of collateral, there's a big misunderstanding I see when a lot of folks come to my office, and I think a common misconception for people who have never had any relationships with bankruptcy, that you can file a bankruptcy and discharge or wipe out debt on your house or your car and still keep those items. It doesn't work quite like that. If you keep those items or any secured debts, you must still pay for those items. That brings me to talk a little bit about secured debts and how they are handled in a Chapter 7 proceeding. You have to make decisions about those debts. Secured debts, as I'm sure you're all aware, are the ones where you have collateral on a note, like a vehicle or a home. In some cases, furniture or electronics, things like that. These debts either need to be reaffirmed or surrendered. In order to reaffirm a secured debt, basically reaffirm means you are reaffirming or sticking to the terms of your original contract with that creditor. I like to tell people, you keep paying that person like you never saw me. You keep making those payments each and every month like you always do. Somewhere along the way in the process, there is actually something called a reaffirmation agreement, which the creditor will enter into with the Chapter 7 debtor, stating that they do reaffirm the terms of their original contract, and they'll continue to go on and pay. Or if you think it will be too much of an undue hardship for you to keep that item of collateral, you may surrender that item of collateral back to the creditor. Once you decide to surrender the item of collateral, it then becomes an unsecured debt, equivalent of a credit card or a signature loan, and that can then be discharged or wiped out in the Chapter 7 bankruptcy. I'm seeing a lot more of this right now in the economic situation. Folks are choosing to let their houses go back or their autos go back because it would be too much of an undue hardship with a lot of folks right now to keep those items and pay for them. In some circumstances, there are additional debts that can be discharged in a Chapter 7. Sometimes you can discharge or include in the Chapter 7 back taxes. There are some special circumstances to meet. The tax returns must have been filed for at least 3 years with no activity on the accounts at all. We don't see too much discharge of taxes. Usually it's when folks owe back taxes, it's because they haven't filed in a while. So that's a pretty rare occasion. Another thing that can sometimes be discharged in Chapter 7 is a student loan. This is an even rarer occasion. There must be very, very, very special circumstances and a true and serious hardship as to why you can't discharge the student loans. We don't see that very often, and as a matter of fact, the last one I would have tried to discharge several years ago, I thought was quite an undue hardship for the person to pay, but the government did not think so. So they're still paying back their student loan. The code also lays out for us some exceptions to a Chapter 7 bankruptcy discharge. If you look at the code, you can find those exceptions in 11 U.S.C. Section 523A. These things include alimony, child support, debt stemming from willful or malicious acts, and death or personal injury caused by DUI. Also includes any debts incurred through fraud. A lot of times the fraud exception is a very hard one to prove. The others are not so difficult to prove, and it's basically just a given that some of those cannot be discharged under the new code. There are also certain exemptions allowed to debtors. These exemptions are things that debtors can keep or that are protected by the law, certain items of property or assets that you can protect. There is a federal exemption scheme out there, but Alabama chooses not to follow that. A lot of other states have their own exemption schemes as well that you can find in state law of each state. In Alabama, there are certain limits on real property and personal property. An individual debtor is allowed $5,000 in real estate to be kept that cannot be touched by their creditors. They're also allowed to keep $3,000 apiece in personal property. This $5,000 worth of real estate and $3,000 worth of personal property isn't subject to seizure by your creditors or by the bankruptcy court, and if you file a Chapter 7 bankruptcy. If you have assets over and above these property limitations, they may be subject to sale or seizure by the bankruptcy court. These cases would be called asset cases. I, in my practice, don't see a whole lot of asset cases. There is another way to protect these assets sometimes in a bankruptcy, and that would be by filing a Chapter 13 bankruptcy, which is another form of consumer bankruptcy. A Chapter 13 bankruptcy works more like a debt consolidation is what I tell most folks. Taking your monthly bills, putting them into a monthly payment plan, and having you make a payment each and every month is the premise of a Chapter 13 bankruptcy. When we file a Chapter 13 bankruptcy in our district, most of the time these payments are done through a payroll deduction if you are employed. Your employer would simply take the money from your check and send it straight to a bankruptcy trustee, who would then send it out to your creditors each and every month. I sometimes like to call him the middleman for these proceedings. Talk a little bit more about trustees in a moment. when someone decides to file a Chapter 13, that person must include all of their creditors. I always tell people that's not my rule, that's the law. The law doesn't allow for preferential treatment of any creditor. You have to treat them all equally under a Chapter 13 and pay them all through the plan. Most of our Chapter 13 plans here are 5-year payment plans or 60 months. Most Chapter 13s are generally used to do things like stop foreclosures, repossessions, catch up on mortgage payments. You can also pay some of those debts that are non-dischargeable in a Chapter 7, like back taxes, back child support, and student loans. These would be called priority debts, and they deserve a status that they get paid in full through a Chapter 13 plan, whereas you can't discharge those in a 7, you can pay them through a Chapter 13. That's helpful for a lot of people who have the tax situation, back taxes. Depending upon each debtor's situation, Chapter 13 plans are sometimes filed as what we would call a pro rata plan or a percentage plan. The official name we use in the courtroom is a base plan, meaning that you're not necessarily going to pay all of your unsecured creditors back in full. You get a little bit of a break. We can pay those back at a percentage rate, which is helpful to a lot of folks. A lot of these unsecured debts, like credit cards and things, have generated quite a few fees or interest, accrued interest, and by paying those at a pro rata, it makes a little more sense for most folks. And it's very helpful in a lot of situations. Now, things like auto loans, mortgage arrearage, or other secured debts, you must pay in full through the Chapter 13 plan. Sometimes we are able to reduce the interest rate based on some previous decisions by the 11th Circuit Bankruptcy Court. We're able to reduce the rate from your original contract rate to a more reasonable rate to be paid through the Chapter 13 plan. For folks with a limited budget, that works a lot better, and they're able to keep their mode of transportation to go to work by paying a reduced interest rate. There is some legislation out there right now that may in the future allow us to cram down mortgage interest or second mortgage lien amounts under a Chapter 13 bankruptcy. I think if that passes through, we'll really see that influx in new filings that I mentioned earlier. There were a lot of changes with the 2005 Act, with the Bankruptcy Abuse Prevention Act. Significant changes. One of those significant changes was that debtors are now required to do pre-petition credit counseling at the debtor's expense. This credit counseling must be done within 180 days of filing their petition with the court. Debtors also have to complete what's called debtor's education or a financial management course after they file their bankruptcy petition, whether it be a Chapter 7 or a Chapter 13. This was enacted hopefully to make people feel like they can manage a little better and maybe won't have to come back to see us again to file another bankruptcy. Congress also enacted something called a means test. It's something that all debtors must complete and file along with their petition and schedules with the bankruptcy court. This is a look back at the debtor's previous 6 months' income, or an average of their previous 6 months' income. This determines what we call in the bankruptcy world the current monthly income. Each state has a median income per debtor to determine eligibility of whether or not you can afford to pay back some of your creditors or not. The median income is determined by your household size. With the means test, you can also deduct debts for your payments on your secured debts and deduct reasonable and necessary expenses. Sometimes the problem with the reasonable and necessary expenses is those expenses are set per state, per county by the IRS. So we are mandated those expenses of what are reasonable and necessary. In some ways that's good, and in some ways it's bad. But the IRS has set those. They do update them with the economy generally. They go up, they go down, and we use whatever is the mandate at the current time for those reasonable and necessary expenses. If someone comes to me that's above the median income under that means test, they're generally not eligible to file the Chapter 7 form of bankruptcy and must file the Chapter 13 bankruptcy and pay back a portion or all of some of their debt. Another significant change with the 2005 law was stricter time limitations on refiling bankruptcies. They pushed the time between Chapter 7s to 8 years from the date of filing. It was previously 6 years, and now it's 8 years. If you have a prior Chapter 13 discharge, you may be eligible to file a Chapter 7 at any time if you paid your creditors in full and passed a good faith best effort test. If your Chapter 13 was one of the pro rata plans I mentioned earlier, you may have to wait up to 6 years to file a Chapter 7 bankruptcy. If a prospective debtor has a prior Chapter 13 and needs to file another Chapter 13, they must wait at least 2 years from the filing date of the original Chapter 13. With these stricter time limitations, it's made quite a mathematical equation for us to figure out whether or not folks are eligible to file 7 and 13 and how long they have to wait. It's a little bit of a challenge when a previous filer comes to see us. There are several provisions of the code as well that are very important to a lot of prospective debtors. One of these is the automatic stay. If you look to the code, you can find that in Title 11, Section 362. This stay will go into effect upon the filing of any bankruptcy petition, whether it be a Chapter 7 or a Chapter 13. And what it does is prohibit the creditors from any type of collection against the debtor. This includes repossessions, foreclosures, harassing phone calls, any type of letter to collect the debt. This is a huge relief for most of the people that come to see us, because most people have held out so long they've begun to receive these harassing phone calls. And it's a big, big relief when we're able to tell them that that's going to stop very soon. The only way for a creditor to get around this stay provision, they must file a formal motion with the court to be set for a hearing that's called a motion for relief from this automatic stay. They must have a legal reason behind it in order to file it. Another important factor in what any debtor comes for is the discharge in a bankruptcy. Discharge is when you can start to rebuild your credit. I like to tell my clients that you'll receive an actual piece of paper that says discharge of debtor, and to hang on to that because it is like your bankruptcy birth certificate. Future creditors may want to see that. It's a very important piece of paper once you come to the end of your bankruptcy. The discharge provision is found in 11 U.S.C. 524 if you look to the code, and it virtually ends the bankruptcy process. Once the discharge is entered, those debts are gone forever. Creditors cannot come back and try to collect on any of those debts. Some folks ask me if they can go back and pay those people if they're ever in a better position to do so. You can voluntarily pay back creditors you have discharged in a bankruptcy, but they can never make an effort to try to collect on those debts. The process of filing a bankruptcy is quite simple. Once people make the decision to come through my front door, they meet with an attorney the first time they come in. And what we try to do is sit down and evaluate that person's debt situation. They do meet with an attorney each time they come in. Once we talk about which chapter they may be eligible for or what might work best for them and explain the options, we generally meet back with those folks between 2 and 3 times where they're required to provide information like paycheck stubs, tax returns, information about their assets and liabilities, and information about their creditors in order for us to be able to file their petition with the court. Debtors are required to sign their petition under a penalty of perjury, so we do a pretty thorough examination on the information they provide us. After approximately 30 days of the filing of that petition, each debtor is required to attend a meeting called a 341 meeting of creditors. The term 341 comes from Section 341 of Title 11. That meeting is usually presided over by the Chapter 13 trustee or Chapter 7 trustee, either one. but it is a meeting of creditors. It allows any creditors to come and ask the debtor questions about how their debt will be treated in the bankruptcy and their intent as to the debt. The trustee in a Chapter 7 or a Chapter 13, I've mentioned several times, he or she is the person who administratively oversees the case. In a Chapter 13, they collect the money and handle the claims of the creditors and actually pay those creditors. In a Chapter 7, they oversee if there are any assets to be provided to the creditors through cases. Our division currently has 2 Chapter 7 trustees and 2 Chapter 13 trustees who oversee all our cases. There's an interesting article that's enclosed with your materials tonight that was recently in Newsweek magazine. The author of the article, I don't think, was initially always fond of bankruptcy, but it seems like with the current economic downturn, she's realized that maybe that's sometimes the best thing to do. A good observation she makes is that sometimes people generally hold out way too long to come and see someone like me because they feel like it's an embarrassing situation. But one thing you shouldn't do, and we advise people not to do, is wait too long. We'd like to help them as soon as possible. I like to assure those folks who wait too long to come and see me that it's okay to do this, or else there wouldn't be a whole book, a whole Title 11, and a whole section of the United States Code dedicated to the process of bankruptcy that we've discussed here tonight. Question?
On Title 13, particularly while they're paying back, can they continue with finance and interest charges?
Secured creditors generally do receive an interest rate through the plan. Unsecured creditors, in most all instances, no longer accrue any interest or late charges or finance charges. Any other questions?
Is there an effort to change the 2005 amendments to the bankruptcy law?
There is. That is what we hear with the new administration, that we're hoping for possibly some amendments to that 2005 Reform Act.
What is your observation as to the effect of those amendments, which were passed obviously to discourage bankruptcy and to help creditors?
In my opinion, the means test doesn't make a lot of sense because it's a 6 months look back. I would like to see some changes in that for the debtor's more current situation, because that's why they're coming to me, is what their current situation is, not their last 6 months.
What about this credit counseling that they require the debtors to go through? Do you think that's been effective?
In a few instances, maybe, but in most instances, no.
In your case, being probably seeing more bankruptcies than anybody in North Alabama, how many times would you say that the credit counseling actually helped the debtor?
Oh, 10% of the cases, maybe. Yes, ma'am.
My question goes back to the property amount of $5,000 and the $3,000 of personal property that were allowed to be retained. Are those numbers that go up with inflation, or are they just horribly out of date?
They're set by the Code of Alabama, and in my 11 years of practice, they've never changed, and prior to that, they'd been in place for a long time.
The value of $5,000 that a person could conceivably live in.
Go down to the courthouse. My deed says my house is worth $10 and other considerations.
Now, you can't be too tricky like that.
So my house is worth $10. I get to keep it all.
That's great. Anyone else? I'll turn it over. Yes, ma'am.
If a husband and wife, if only the husband or the wife files a bankruptcy, how is that handled as far as, the mortgage, the personal, real estate property and all?
Well, if the debts are if the debts are individual debts, it has no bearing. A spouse could file individually. If they are joint debts, in most cases, I do advise a joint filing. It depends upon each debtor's particular situation, though, of whether or not I would advise that. And in some instances, if only a few debts are joint, in a Chapter 13 bankruptcy, we can protect a co-debtor on just a few debts.
If somebody goes to file or come to you and talk about their situation, would a portion of that filing be under a 7 and a portion under a 13, or do you have to make a choice, it all goes in one basket or the other?
You do have to make a choice of whether to file a Chapter 7 or a Chapter 13. It goes back a little bit, though, to the Chapter 13, the pro rata plan I mentioned, where you do pay your secured creditors, but you maybe only pay a percentage to your unsecureds. That can kind of be thought of as maybe a little bit of a Chapter 13 and a little bit of a Chapter 7, because you do get a discharge of some of your unsecured debt.
How will you guarantee payment for your services if you're dealing with the situation?
That's a good question, I suppose. In Chapter 13 debt consolidation plans, we generally include the majority or all of the fees and costs in the payment plan. We go in right along with all the other creditors and expenses. In most instances in a Chapter 7, we handle our fees and costs up front. I'm going to turn it to Ron now, so he has plenty of time. Thank you.
Do y'all have another half hour? Hopefully. My name is Ron Sykstus. I was born and raised in Chicago, and so you'll hear a little bit of an accent, though I think the last 10 years with Amy has kind of mollified my accent a little bit, and I've picked up a little bit of, I guess, Southern language. But in any event, what I'm going to talk to you about today, I'm going to switch gears a little bit, and I want to talk about security clearances. And if we have some time permitting, and hopefully we will, I want to touch on a couple of important consumer laws which I've provided in your materials. Can I see a show of hands of who's had a security clearance, either does now or has had one? Okay, so a good amount, and obviously where we live, I always tell folks, a clearance is paramount to the types of good jobs that we have here. A security clearance is a government designation that allows individuals to have access to classified materials. And what I tell folks is, maybe 6-7 years ago, I would say 30%, and if anyone disagrees with me, let me know, maybe 30% of the work that the government and the contractors did, was classified. Now I would say within the last 2 to 3 years, I would say it's about 60%. Does that seem about right? Well, let's say it's going more and more to classified material. So when someone gets a job, either a government job or a defense job, a defense contractor job that requires a clearance, they tell them, they put in for a security clearance for that individual. I never get involved unless the clearance is denied or revoked. So a couple of ways it happens, and I just kind of want to talk about evolution of a case from my perspective. So first of all, someone has a clearance and they get what's called a statement of reasons to revoke the clearance by the government. Believe me, that sends off warning bells for everyone, and y'all may have known some folks who have gotten that. Or if someone applies for a clearance at the outset and the government says, I'm going to issue you a statement of reasons, or the government's going to issue a statement of reasons that we're not going to give you a clearance. So term of art is the statement of reasons, and that's issued by the government when they're going to either deny or revoke clearance. And it'll give specific reasons why the government doesn't want to give a clearance. And I put a little something in your materials. It's DOD Directive 5220.6, and that controls everything with regard to a clearance. I didn't give you the whole regulation. I didn't figure you'd need it, but at least you've got the reference materials. So when you're given this statement of intent or statement of reasons to revoke a clearance, it'll say you can submit a rebuttal statement or you can request a hearing before an administrative law judge. So the applicant generally has two options once they get this statement of reasons. And again, in this town, and it's obviously this way in D.C., when someone gets this, they are catatonic. And again, two options. They can submit this response in writing. And for those of you who know about the government, I would never do that. And I'll talk about that in a little bit. Because all it does is travel up to Fort Meade, Maryland, and this is my analogy. A clerk at Fort Meade sees it right before lunch and says, no clearance, and you're done. So all it is a written statement you can submit with some supporting documents why you should be given a clearance. Now the other option is to request a hearing before an administrative law judge. And now that kind of turns it into an adversarial proceeding. So these hearings before a judge, they're adversarial. Both parties present their case. That's the duty. The applicant has a duty to represent his or her case. So does the government. The government will have a defense counsel representing their case. Now the applicant has the option of representing himself, or being represented by an attorney, and this is not one of those bailout issues, by an attorney that he or she selects and pays for, unfortunately, and or also a personal representative. They can have a friend do it, a parent, a security officer. The government won't touch that, but a lot of times I've seen security officers at facilities do it for them. And some of them, I can think of two, do a wonderful job. Now, I think presenting a case, they can of course do it alone. I really try to discourage that. At a minimum, I'd rather see them do it with a third party, because it just sounds hollow when someone does a case on their own. You know, Your Honor, I'm a great guy, and let me tell you about all the wonderful things I've done. That kind of rings hollow versus a third party, a third party presenting the case. Now the hearings, I told you it's based out of Fort Meade, Maryland, but the hearings are held in our locality, the locality of the applicant. So that's not bad, and as a general rule, the hearings here will be held in Huntsville. And in fact, I've had, I think, 3 or 4 hearings in this building. So it's a pretty informal process, which I'll get to in a second. As far as the process itself, you know, as I said, it's an adversarial process, but the judge is not empowered to issue a subpoena for witnesses or documents. So anything that you want to bring as the applicant, you've got to provide yourself. You've got to provide your own witnesses and your own documents. When I say documents, I'm talking, evidentiary documents, which I'll get into in a second. If you have a lawyer representing you, that lawyer has to issue what's called a notice of appearance with both the department lawyer, the department counsel, and the hearing office itself at Fort Meade. With regard to these cases, wide degree of discretion as far as presenting your cases. Here's kind of the trick. Rules of evidence, you think they would, but they don't apply. And what that means is everything comes in. I've seen government documents. This always kills me. I've had cases that are like foreign influence cases where the government says, hey, we don't want to give you a clearance, or we want to deny your clearance because you've had some issues with a foreign country, Thailand, Taiwan. But the government will introduce 5-year-old documents, to say, off of Google, that's where they get them, that say, hey, we've got, our country has issues with this country. As a result, we've got concerns for you. But they'll ignore a 6-month-old document that says we sold $2 billion worth of weapons to this country. So, but again, and when I get these documents, a quick Google search will usually give me more updated facts. So the way I look at a case, I always request a hearing. I've already kind of said that, but I think that's the way you start it. I really think submitting a rebuttal statement is a waste of time, and it's as good as waving goodbye to the clearance. And again, for the jobs in this area, that have a clearance, it's important, and longer term, it's important for advancement, and because in my assessment, once folks get a clearance, then they can move up the chain pretty quickly. So, as far as presenting a case, there's 1 of 2 ways you present a case. So the government says, here, we're going to issue this statement of reasons of why we're going to revoke your clearance, and here's all the conduct that you've done. This is why we want to pull it from you. So you can do it 1 of 2 ways. You present it where you contest the conduct. Hey, this conduct never happened, or, which I will say I've never seen, the conduct's always happened. And we kind of know that because I said the rules of evidence don't apply. So they've got all these documents already in evidence as far as unsworn statements, police reports, it all comes in. Divorce decrees, bad checks. All this stuff's in. Some of it's illegible, but it's there. So I've never had a case where I could fight and say, hey, this didn't happen. So I always present it or approach it from the standpoint it did happen. So what I want to do is explain the conduct in great detail. That's how I approach a case. In my cases, the applicant always testifies. I don't want to give away too many of my trade secrets, but applicant always testifies, and I like to kind of walk through the conduct. Sometimes in excruciating detail. But the reason I do that is I want to take the sting out of any cross-examination questions. Supporting witnesses. You can bring in 2 types of witnesses. conduct witnesses and character witnesses. I want to have both. I want to have witnesses come in that talk about, you know, the character of this guy or this girl. Hey, she's wonderful, and this is what she does in the community. I've had pastors testify, which I think is great. A lot of these judges are from Virginia. In my experience, when I was in the JAG Corps, I was stationed in Virginia for a period of time. It's much like Alabama. It's a very church-going population. So if I can get a pastor in, I mean, that really helps our cause. You know, if they attend church regularly. So I also want conduct witnesses, and if we have someone, sometimes the conduct can be a little, you know, for lack of a better phrase, a little unseemly. But if we can get into that a little bit with conduct witnesses who know about it and who can kind of explain it away, that's very helpful to our cause. You know, I said the judges don't have subpoena power to produce documentary evidence, but what I like to do is get all sorts of, you know, awards. Can I see a show of hands prior military? OERs, I like to get officer efficiency reports, and in my day, and maybe in y'all's, in my day they were greatly inflated. I don't like to tell that. So, I mean, they usually look great. EERs, enlisted efficiency reports, I'll get those if we have prior military experience. A lot of the contractors here in town and the government issue yearly performance appraisals, which are another great source of evidence. And again, generally, as long as you've been a good employee, they're going to look good. So I introduce that. I've done college diplomas. I've done college transcripts. In one case, I did a high school transcript. You know, anything we can get to kind of bolster this person. One of the, in the regulation, the judge is required to look at the whole person concept. So that's why, again, we have the conduct, but the more we can kind of bolster this whole person, this character information, so much the better. So we've got each guideline that states, each guideline that we're talking about, when the statement of reasons is issued, it talks about the specific conduct. And each one of them says, you know, why we're going to pull it, and whether it's financial, drug abuse, alcohol, that type of thing. And I want to touch on that a little bit. In every one of these guidelines, there are mitigating circumstances. So I said there's the whole person concept, just generally good person, and then mitigating circumstances on what charges or what conduct they're alleging. Guideline E is personal conduct, and I think I've got some information in y'all's packet. And this is conduct involving questionable judgment, untrustworthiness, unreliability, or dishonesty. And there are certain mitigating circumstances that the government, or the judge, I should say, will look at in order to maybe say, maybe this person should get a clearance. For instance, one of the mitigating circumstances, the information was unsubstantiated or not pertinent to a determination of judgment, trustworthiness, reliability, etc. On the security clearance regulation, where this guideline E always comes up, it's the document itself. And here it is, all 19 pages. This is a security clearance application. I think the last 3 or 4 years they now do it online. They require it to be done online. It's now called, it's an SF-86, Standard Form 86, which has been in place for, 20, 30 years. It's now also called an Electronic Personnel Security Questionnaire. Again, they require you to do it online. And I just kind of want to touch on some of the questions where I've seen folks, every one of these questions I read, I've seen folks get tripped up. They have a question on foreign influence, on former spouses. Let me talk about that for a moment. And they want to know if divorced, annulled, etc., where is the record located? And unfortunately with the volumes of divorces that are out there, there can be some, for lack of a better phrase, tawdry things put in a divorce pleading. So the government can access that entire record. If you simply have a cohabitant, they want not only the relationship to you and the cohabitant, they want that person's social security number, and that's kind of how this starts. As far as they have a question, I mentioned foreign influence if you've lived in a foreign country. A question, do you have or have you ever had any foreign financial businesses, foreign bank accounts, or other foreign financial interests, etc.? Yes or no? Bear with me, they get better. Police record. There's a section that has about 8 questions. Have you ever been issued a summons, citation, or ticket to appear in court in a criminal proceeding? Have you ever been arrested by any police officer, sheriff, marshal, or any other type of law enforcement? Just arrested. Have you ever been charged with a felony offense? Illegal use of drugs, another 7 questions here. In the last 7 years, have you illegally used any controlled substance, for example, cocaine, crack cocaine, THC, marijuana, hashish, narcotics in this same question, or prescription drugs, including painkillers? Use of alcohol. Has your use of alcohol had a negative impact on your work performance, your professional or personal relationships, your finances, etc.? So pretty generic question. They're not asking about have you gone through rehab or anything like that. Financial questions. This can be a killer for folks. And what I'm talking about here is just the way these questions are answered, because under this guideline, what I always see is not just the conduct that gets charged, whether it's under Guideline F, inability or problems with finances, or the problem with alcohol. It's the way these get answered. Let me just read some of these questions on a financial record. Have you ever had a judgment entered against you? Have you defaulted on any type of loan? Have you had bills or debts turned over to a collection agency? Have you had any account or credit card suspended, charged off, or canceled for failing to pay? This isn't, these two, and I always see folks get tripped up here. Have you been over 180 days delinquent on any debt? Are you currently over 90 days delinquent on any debt? I've seen that 90-day question answered incorrectly. Person didn't even know about it, and now they charge this Guideline E. You've been untruthful. You're not using candor. And these judges, let me say a word about the judges that we face at these hearings. These judges are good folks. I mean, I've been, uniformly impressed. In fact, one of the judges was my commandant at the Army's law school when I was there. So fast forward 20 years ago, or 20 years later, and there he was. Now, on that one, he ruled against me, if you can believe it. But I like to think it was more the facts than my presentation. But I've seen people get tripped. This is where they get tripped up. It's that candor that these judges, and I just said they're good folks, but if they get a little, I guess, squirmy feeling about the candor questions, I mean, they can use that to knock out a clearance. So that's a pretty tough, and when people are filling this out online, I mean, I've looked at it online, and it takes some time, and it's a little complicated and convoluted when you're filling this out online. I always tell folks, if I have people call me to say, look, how should I answer some of these questions? I always tell them, don't answer it online. At least type up the question and answer for me. Let me see it, and we'll kind of talk it through and see if we can come up with at least a cogent response that makes some sense. So that's that guideline. Guideline F is financial considerations, and that's for a person who's financially overextended. So some concerns or mitigating factors the government will use to grant a clearance is that the behavior was not recent. It was an isolated incident. The conditions resulted in behavior that was largely beyond the person's control. A loss of employment, I've had that. Business downturn. I had a great guy who started a business, and I won't go into those details, but started a business, and a big store came in and competed directly with him, lost his business, but we were able to show that was the cause of his downturn, and he kept his clearance. And again, a great guy. Unexpected medical emergency or a death, divorce, or separation. It also allows for financial counseling or legal ways. It specifically says in there legal ways to tend to your debt situation. So that's where you've heard Amy talk about bankruptcy, and we get this question quite a bit. If I file bankruptcy, what's the effect on my credit? Or what's the effect not only on my credit, what's the effect on my clearance? And here's the general rule. This is kind of unwritten, but what I've seen, one bankruptcy in a lifetime, as long as there's nothing more, there's not a DUI, I've had it out, DUI, drug running, some other things like that. As long as if there's just one bankruptcy, no effect on the clearance. 2 bankruptcies in a lifetime is potentially a problem. And there's a way to maybe kind of navigate around that, and it's something we talk to our clients about. But that second bankruptcy can pose somewhat of a problem, potentially. But you know, a bankruptcy and something else. So you have this guideline F, financial overextended, and then maybe if we have drug issues or alcohol issues, that can create a problem. But just one bankruptcy and nothing more, no problem. Guideline G is alcohol consumption. And the conduct that can mitigate that there is that the alcohol-related incidents do not indicate a pattern. I think one DUI is okay. Well, it's not okay, but one DUI, you can still keep a clearance as long as you've kind of taken care of the issue. I think 2 DUIs is a problem. I've had a DUI and a couple of public intoxications when they're younger, potentially a problem. Let me say something real quick, going back to that question, the questions I was reading. Have you been convicted or charged with a felony? Even that question, I've had people answer no when they were charged with a felony, but they pled it down to a misdemeanor. A felony is defined simply as over a year in jail and generally over a $1,000 fine. But that year in jail is kind of the linchpin for a felony charge. So answered no, and the judge in that case made a huge issue that, hey, you lied, you weren't candid. Well, I pled it down, so I thought that's really what the question meant. Well, no, the real question was, we just kind of get into that parsing word. So, let me talk a little further about the alcohol. So again, as long as there's no pattern there, as long as there's an intent towards sobriety and there's some type of, I've had folks that go into AA and testify to that. I had one person who didn't really do AA, but went to his minister quite a bit, who was actually familiar with the AA type programs, who testified for us. And again, wonderful witness. The gentleman was wonderful. The applicant was a great guy. He kept his clearance. Drug involvement. Drug involvement can be a little trickier, and I always tell folks, again, you've got to answer this stuff truthfully, because when the Army vets these clearances, they start going, they'll do a pretty serious background check. And if they have other folks that have maybe been convicted of something and you've answered no, it gets real tricky. But as long as the drug involvement wasn't recent, and most importantly, if there's a demonstrated intent not to abuse drugs again, if they see that in writing, and now this is the time a rebuttal statement is pretty effective. They see that in writing, that'll kind of go a long way. So that's really, bear with me, I'm kind of losing my papers here. That's really it with the guidelines. That's where we see most of the issues. Now, what happens at the end of these hearings? And again, they're thorough hearings. I didn't mention that there is a court reporter present. The court reporter takes down everything that's said, both by the applicant, the department counsel, the judge, takes down everything. And usually these transcripts run a couple, 300-400 pages. This is the one time the government does give the applicant a free copy, fortunately. From there, the judge makes his decision, and it's always in writing. The applicant wants it right there. But the judge issues his decision in writing, and they're very, very thorough, very thorough. And I tell folks, once the judge makes that call, the one good thing about this process, the judge is the sole arbiter, if you will, of this decision. If he says, even though he works for the government, and sometimes even though he dines with department counsel at lunch, if he says keep the clearance, by and large, the person will keep the clearance. Now, the government has the right to appeal. So does the applicant if there's an adverse decision. But that appeal process is very quick. It's 15 days. You've got to have an appeal submitted. And I always tell folks, I hate that appeal. If you're appealing a judge's decision, chances are it's not going to be good, or it's going to be tough, I should say. The government sometimes appeals. I've had some cases where the government appeals. I view it as a case of sour grapes, and I guess they could view it if I appeal the same way. But once that judge, and those judges' decisions are pretty thorough, like I said. So one last thing, can you appeal? So let's say you get a negative decision by the judge, you submit an appeal to this appeal board, and the appeal board still denies you. What can you do then? You're kind of stuck. You can reapply for a clearance in 2 years. By then, you kind of know what the issues are, whether it's a situation of getting into some type of sobriety program or managing the debts a bit better, doing something about that, or whatever it is. You cannot appeal to federal court. I've had some folks who wanted to try that. Hey, let's go. I want to go to court. I think I've been wronged. What the federal courts say is, we're not touching security clearances. This is solely the purview of the government. I mean, the government decides we don't know anything about it, though they think they know about everything else, but we don't know anything about this and we don't want to mess with it. So you're really stuck once you get to this point. Let me touch on two real quick things that are in your materials. I want to talk, now I'm going to switch gears and go back to Fair Debt Collection Practices Act. Real important consumer law. It's 6 pages and it's in your materials, and it is a great tool and mechanism, especially in this climate, as Amy said, if folks are being harassed by debt collectors. And there's an awful lot of that going on. I always tell folks the first part of that, the statute's actually in your materials. Again, 6 pages. The first part of it talks about congressional intent. It was, the law was enacted in 1977, the fall of 77. And what Congress said in the first part of that law is, we think there is abundant evidence of abusive debt collection practices, and essentially we got to stop it because it leads to all sorts of bad things. That's 1977, Congress says that. You know, fast forward to where we are today, 30 plus years, and that's before the real explosion of credit card debt and that type of thing. So there are ways to put debt collectors back on their heels, and there's a lot of stuff that is done out there that they're not allowed to do. One last thing, Fair Credit Reporting Act, that's the law that applies, and again, as a follow-up to Amy on consumer bankruptcy, Fair Credit Reporting Act is the law that applies when you have problems with your credit report. Credit report shows errors. I think the studies are that over 50% of all credit reports that are out there have errors. And this is the law that talks about how you go about correcting it. Most important thing I can say here is make sure you get your free credit reports from the government site. It's annualcreditreport.com. And again, some of that information's in there, but only use that site. Don't be lulled into the ads that talk about, I'm going to not name them, but there are other sites and you may have the jingle in your head. Only use annualcreditreport.com. That's the free government site. If you use any other site and if you do it online, here's the trick. If they mess you over, if your credit report has errors, you're not going to be able to sue to correct it. You enter into what's called binding mandatory arbitration and you waive your rights to sue. And it's fine print. You won't even see that language. And I've had a number of clients get stuck that way. So I've got the form and appreciate y'all's time. Thanks.